Hello, my name's Julian Salt. I'm a solicitor and I work for Pennine Law, and I specialise in wills, probate and the administration of estates.
Why is it important to write a will?
That's a good question, and what I'm going to do is take a broad brush approach to this. And the reason why it's important to write a will is so that you can ensure that your assets pass to your loved ones or the correct beneficiaries named in your will. Broadly speaking, the intestacy rules in England and Wales, that is, when you pass away without a will, are inflexible. So therefore, if you want to ensure that all of your assets pass to the individuals or even charities, then you can name them in your will and it'll ensure it'll go to the correct person.
So once I've written my will, can I change it?
Yes, you can. A will is a fluid document, and what I mean by that is that it only crystallises on death. This means that you can change your will at any point between when you sign your first will until the day of your passing.
When I write my will, I understand I need to add an executor. But what is an executor?
An executor is an individual who administers your estate. What they will do, they will assess what's in your estate and write down all of the assets and liabilities in your estate, and then depending on what assets and liabilities you have, you may have to apply for a grant of probate. I'm not going to cover that in this particular video. However, what they will do is gather in all of the assets and then distribute it in accordance with the will.
If I'm married, do I still need a will?
A lot of people are under the impression that if you are married, that all of your assets automatically pass to your spouse. Now, depending on how your assets are arranged and the amount of assets that you have, and what I mean by that is monetary value, they may pass to your wife or your spouse. However, if you have over a certain amount in assets, then there are different laws with regards to that. So therefore, it is very important to make a will even if you are still married.
So some of the things that I own, they're not just physical items. Yes, I own digital assets too. Should I include them in my will as well?
That's another good question. With regards to the digital assets, this has been coming for a while now. However, it's in its infancy with regards to digital assets. There are numerous platforms out there, whether it be Facebook, Twitter, Instagram, Apple ID accounts, and each individual platform has a different policy with regards to what happens when somebody passes away.
And what would be considered a digital asset?
Digital assets are assets that have value to you but are actually held on a computer. So examples of digital assets are photos, audio files and videos. Written assets such as presentations, Excel documents, Word documents. Cloud storage is another digital asset, so you may have photos on a device which is also backed up in a cloud. Social media platforms such as Instagram, Facebook, Twitter, Snapchat. Furthermore, there's also financial assets as well, so cryptocurrencies, selling and buying accounts, and there's a whole raft of other things that can be deemed a digital asset. Now, if you made a list of all of your digital assets, then I think an individual will be quite shocked of how many digital assets they actually have.
So what are the key issues that relatives face when trying to deal with a deceased loved one's digital assets?
One of the key issues is having access to the account and knowing what digital assets they have. What you can do is make a list of all of the digital assets that you have, so that is all of the accounts, usernames and things like that. so that the executors know what digital assets that you have. One of the big problems, I think, going into the future is going to be executors may not know what digital assets you actually have. So therefore, if you list all of them and they have them to hand should something happen to you, it's going to make the executor's job far more easier.
So how can someone include digital assets in their will?
They can include digital assets in their will by giving what's called a specific gift to somebody. So they say, I give this particular asset to this individual. Anything that is not referred to in the will with your digital assets passes into what's called the residuary estate and will be divided between all of the beneficiaries that are listed within your residuary estate.
What happens to your online subscriptions and digital downloads after you die?
To be honest, this question is as broad as it is long. Each individual institution has their own policies with regards to what should happen to deceased accounts. You would have to check every individual platform that you have a digital asset interest in and then determine what the best way is to deal with that particular asset.
How can a solicitor help you plan your digital legacy?
We can assist you by pointing you basically in the right direction with regards to your digital assets. Now, with things that digital assets that have value, and what I mean by value, such as cryptocurrencies and things like that, they will fall into your residuary estate, or you can gift that to a certain individual depending on the terms and conditions of that particular platform that it is on. But the best way we can help you is to help plan for your digital assets and make you aware that each individual platform has different terms and conditions of business. Furthermore, it is worth completing what we call a digital asset register, whereby what you do is say, right, these are all the accounts that I have, these are my usernames, and therefore the executor of your estate can then access those accounts after you pass away, and if you have chosen to do so, close them down. Another question that we get asked is, what information do we as a solicitors need to know when a client comes in to make a will? So the information that we require from you is, broadly speaking, what are all of your assets in your estate? What is the value of them, so we can make judgments of whether you have any inheritance tax liabilities. And furthermore, we need to know how the asset is held, and what I mean by that, is it in a sole name, is it in a joint name, or is it in some form of trust? We also need to know if you have any assets outside of the UK. More and more people are getting holiday homes abroad or may have other assets outside of the UK. We also require identification from the client, so passport, driving licence and a recent utility bill within the last 3 months. And we also require, and this is a little bit of an obvious one, but we need the names and addresses of all of the beneficiaries that you are going to include in your will.